Welcome on this beautiful spring morning to the Greens List CPD seminar on consumer law and its application to personal injuries. It's an unusual topic, I think, but one that's very interesting. I first came across the provisions of the consumer law a few years ago in some pleadings in a dental negligence case. And I have to say, looking at that cause of action caused me to scratch my head a little, because it's not something that we regularly come across in common law proceedings. And unfortunately, it's an area of law where the more you look into it, the more it's like going down the rabbit hole and the more confusing it gets. There's almost no judicial consideration of the application of the consumer law to personal injuries proceedings in Victoria, and it's basically an unexplored area that we think is really ripe for some fearless lawyers to take up the mantle and explore the boundaries and provide some assistance to clients in what their rights and defendants are under what is potentially going to become a growth area. We've got two speakers this morning, and I should have introduced myself before I introduce them. I'm Britbart, for those that don't know me. Our speakers this morning are Lachlan, Allan and Peter Hamilton, both very bright young barristers on our list. Lachlan will be the first speaker. He has been at the bar since 2014. Before that, he spent 18 months as the senior associate to Judge Misso, who was the head of the damages and compensation and serious injury lists of the county court. Lachlan appears in a range of common law and personal injuries matters in all jurisdictions, including medical panel reviews and appeals. This morning, Lachlan will be giving an outline of the framework of the Commonwealth and Victoria consumer laws and an introduction to the different types of personal injuries actions that can be brought under that legislation. Peter Hamilton will be the second speaker. Peter came to the bar in 2015 after a number of years as a solicitor at a number of firms, including some time as a senior associate at Watton and Carney. Peter also appears in all areas of personal injuries, professional and medical negligence and general insurance law, including advising in areas such as privilege and the interpretation of insurance contracts. Peter's talk will highlight some specific examples of the application of the Australian consumer law. Both of our speakers this morning have a keen interest in the law and have written a number of papers on a variety of insurance and common law related topics, which you can find by logging onto the website under their profiles. And there'll be time for some questions at the end, and I'm sure you'll have some because we still have remaining questions. So make sure to throw some exam questions at the speakers. They'll be ready, although they may need to take some of your questions under advisement. So, Lachlan.
Thanks, Michelle, and welcome everyone. The main goal of my talk is to pull the three sources of the Australian consumer law into one easily understood paper that's arranged in some sort of logical order. So you should have two handouts in front of you, which are mine. One's the slides list and another table, which I'll come back to. There are essentially four kinds of actions you can bring under the Australian consumer law that would be relevant to personal injuries. And those are the four I'll be talking about. There's the first being an action against a manufacturer as a result of a safety defect, which is called a defective goods action. The second being an action against a manufacturer as a result of a breach of a consumer guarantee relating to the provision of goods. The third being the same thing but against a supplier. And the fourth being an action against a supplier as a result of a breach of a consumer guarantee relating to the provision of services. I should say I'm not going to go through each one of these slides in absolute detail because the presentation will otherwise be very long, so I'll just highlight the key points. The sources of the Australian consumer law are effectively a Commonwealth Act, which is the Competition and Consumer Act 2010. That's got 3 volumes. It's very, very long. The Australian consumer law text is located at Schedule 2 of Volume 3 of that Act. But in both Volume 1 and Volume 2, there are provisions which affect the operation of the Australian consumer law. And so it's some of those provisions which I've tried to extract out and arrange in this paper in a logical format. In Victoria, we've adopted Schedule 2 to Volume 3 of the Competition and Consumer Act as being a law of our state. And that was done by way of the Victorian Act, the Australian Consumer Law and Fair Trading Act 2012. And you'll note that it says here the Australian Consumer Law text, as enforced from time to time, applies as a law of this jurisdiction. And it's important to note that the Australian Consumer Law text, if you go back to Provision 7, consists of Schedule 2 to the Competition and Consumer Act and some regulations. But what we don't adopt is the entire Competition and Consumer Act. We've only adopted as a law of this state Schedule 2, which is the Australian Consumer Law text. We've also inserted a provision that says, as enforced from time to time, it's adopted. So that means if the Commonwealth makes any changes to the Australian consumer law, we automatically adopt those without the need for Parliament to pass further legislation. The Competition and Consumer Act confers jurisdiction in respect of its subject matter, being the ACL, onto Victorian courts. And that's done by way of Section 138B of the Competition and Consumer Act. And you can see at subsection 3 that jurisdiction is conferred within the limits of the several jurisdictions, whether those limits are as to locality, subject matter or otherwise. So that means that the jurisdiction is conferred subject to the usual jurisdiction of that state court or tribunal, as the case may be. You will see that subsection 2 of 138B, 2A in particular, says that subsection 1 does not apply in relation to a matter arising under Part 3-5 of the Australian Consumer Law. So that part is held back for the Commonwealth and it's not conferred to the state courts. And this will come as a surprise to many people in the audience, but Part 3-5 is the safety defect actions. So technically, any pleadings that you've drawn for the county or Supreme Courts that include a claim for a product, effectively product liability, safety defect, that is a nullity. The court has no jurisdiction. It cannot hear those matters. However, and the reason that we're revealing this trade secret today is because that situation is about to be corrected. The government, as far back as 2015, admitted that that was a mistake, that they did not mean to hold back safety defect actions for the Commonwealth. But for some reason, 2 years have gone by and nothing's happened. However, before it's gone through both Houses of Parliament, it's come back to the reps now, and I think they'll pass it literally any day, is the Competition and Consumer Amendment Competition Policy Review Bill, which will become an act of the same name. And Schedule 14 of that will correct that situation. So it's going to repeal 138B subsection 2, and now state courts will be able to hear product liability actions. But for the last 6 years, as long as the consumer law has been around, people have been issuing proceedings in the county and the Supreme Court, maybe the Magistrates Court, about safety defects when they couldn't. In Victoria, you can bring... This is 224, I should say, of the Australian Consumer Law and Fair Trading Act. It sets out in what courts in Victoria or tribunals you can bring an ACL claim, and it's essentially all of them, right down to VCAT. However, it's important to note that in VCAT, if you're claiming for a personal injury matter, your claim has to be $10,000 or less. And of course, in the Magistrates Court, you've got the usual jurisdictional limits. So as a general rule, and in particular once the bill that's before the Commonwealth House of Reps is passed, you'll want to be issuing in the county or the Supreme Courts, although you might consider a federal court if you've got a pure consumer law claim which doesn't overlap with negligence in Victoria. The Australian Consumer Law and Fair Trading Act also sets out effectively the jurisdiction of the Australian consumer law as it applies in Victoria and as it's heard in state courts and tribunals. And it's not limited, as you can see in section 12(1)(a) to d. It isn't limited, and subsection 2, it's not limited to conduct that occurs purely between two parties in Victoria. So turning to the first of the types of actions you can bring in a personal injury context under the ACL, that's a defective goods action, which is the one that until now has been held back for the Commonwealth courts to hear. It applies to situations, it's brought against the manufacturer, and the manufacturer is liable to compensate either an injured individual who suffers injury because of safety defect in goods that were supplied by the manufacturer in trade or commerce, or 139, someone who suffered consequential loss and damage because of the injured individual's injuries. So you might think a brother or a sister or a mother or a father. As long as, and you'll see 139(1)(e) doesn't apply to someone who's just got a business relationship with the injured individual. So it'll depend who are you acting for as a plaintiff lawyer. Is it the injured individual or is it a family member or the like? The important definitions for this section are, of course, the definition of goods, which is quite broad and is inclusive. The definition of trade or commerce. So I'll come back to trade or commerce when we talk about some of the further actions, and also the definition of what it means to supply something. And you'd also note at this point that the definition of supplier is located with the definition of supply. And again, we'll come back to that when we talk about actions against suppliers. The definition of a manufacturer is located at section 7, the Australian Consumer Law Victoria. The most important thing to note is that you don't have to be the physical manufacturer of the goods in order to be a deemed manufacturer under the Australian Consumer Law. If you are an importer and at the time that you imported the product, the manufacturer didn't have a place of business in Australia, which is very common, you are deemed to be the manufacturer. Similarly, if you apply your brand or trademark to any part of the goods, you will be deemed to be the manufacturer, and there are various other provisions there. So it's a very easy definition to fall within. A lot of people don't know about this section. If you can't find out who the manufacturer is and you're acting for a plaintiff or even for for an injured plaintiff, you can serve what we call a section 147 notice on someone you suspect to be the manufacturer or someone you think might know. And if they don't respond within the prescribed time limit, they'll be taken to be the manufacturer, because it often can be quite hard to work out where some of these cheap imported products actually come from. Here's the meaning of a safety defect, section 9, and I'm not going to go through it in detail, but it's really a question of is it safe, having regard to what you might usually do with a product of this type. So if you're using something abnormally and it breaks and you're injured, then you might not come within the definition of a safety defect or that use. The ACL has specific time limits for these types of actions, which is a 3-year time limit after what we call in Victoria the date of discoverability, with a 10-year long stop period after the date of the actual supply by the manufacturer. I should say, going back to that side, there's no provision to extend that. At section 146 of the ACL, it notes that you are precluded from bringing a safety defect type action in circumstances where you could be recovering your loss and damage under a law that relates to workers' compensation. I'd note that this exclusion, it's the only one in the Act in relation to workers' compensation. It only applies to defective goods actions. So there's no similar exclusion in relation to the other 3 types of claims that I'll discuss. So there's really no reason why you can't be pleading the ACL in the appropriate case where an injury might have arisen out of or in the course of employment. Someone's got to go through the serious injury gateways, but it's potentially a cause of action against a manufacturer or a supplier of certain kinds of goods. As long as you're sticking within the three actions over there and you're not trying to bring a defective goods action. Damages for this kind of claim are assessed pursuant to the Competition and Consumer Act, and in particular Part VIB. It is a defective goods actions, as I've already said, come within Part 3-5 of the ACL, and 87E of the Competition and Consumer Act specifies that this part applies to that type of action. This is probably something most of you have heard about, the most extreme case provisions, which are spoken about in hushed terms, but a lot of people don't understand what they actually mean. There's effectively a stat max which is indexed every year. As best I can tell, and I'm not a mathematician, and it's hard to find out this information, but I think it is currently $332,590 as of September 2016. We can't calculate the September 2017 number yet because the CPI figures aren't out. The court can only award that amount for non-economic loss in what is called the most extreme case. And a most extreme case at 87P2 is a case in which the plaintiff suffers non-economic loss of the gravest conceivable kind, so the worst of the worst. If you are assessed to be less than 15% of the most extreme case, you get nothing for non-economic loss. What about if you're in the middle? Just beginning with the right side of that slide, 87R, if you're between 15% and 33%, it's a non-linear scale. So if you're at, let's say, 28% of the most extreme case, item 14, you only get 14% of the max. So it's a non-linear scale up until 32%. Then once you're 87Q on the left side of the slide, 33% or more, it becomes a linear scale. So if you're 40% of the most extreme case, you get 40% of the stat max. There are further provisions in the Competition and Consumer Act, just like the Wrongs Act, relating to gratuitous care, discount rate, which is 5% for future echo loss, interest on damages, exemplary and aggravated damages, which if you have a case like this you might want to look at as well, but I won't go through now. The Competition and Consumer Act also has effectively a contrib provision for these types of actions. So if you've caused, the injured plaintiff has caused in part some of their loss or damage, it will be reduced by such portion as the court thinks fit. Again, that only applies to these defective goods actions. Now we come to the guarantees provisions in relation to goods. They are at sections 54 and 55 of the Australian Consumer Law. The first guarantee relates to goods being of an acceptable quality. The second guarantee relates to goods being fit, if they're supplied in trade or commerce, to a consumer being fit for any purpose which the consumer has disclosed to the supplier that they need the goods for. I'd just point out in these two guarantees that you'll see in 54 subsection 1 that the supply must be to a consumer. Similarly in 55(1) the supply must be to a consumer. That's not present in the safety defect actions we discussed before. Next we've got, well, what's the meaning of consumer? And essentially you've got to pay less than $40,000 for whatever goods you're acquiring, and that they're a kind that is ordinarily acquired for personal, domestic or household use or consumption. But doesn't have to be on that particular occasion you're acquiring them for that sort of consumption. It's just got to be that they're ordinarily of that kind. So a big industrial machine that's only got a specialised use, you're not going to come within that section no matter how much it cost you. The definition of acquire is also quite important because it also relates to services claims, which we'll come back to. And you can see that as far as goods are concerned, it relates to purchasing, exchanging, taking on lease, hiring or hire purchase arrangements. For services, just means accepting the provision of those services. If you're going to section 3.2, if you're going to reuse the goods in some sort of enterprise, you're also not going to fall within the definition of a consumer. If you're interested in the specific provisions of what acceptable quality means and what a disclosed purpose is, there's some helpful cases listed there. The only thing I'll go to on this slide is down the bottom, fitness for disclosed purpose. It's essentially holds the supplier to a higher standard than the acceptable quality guarantee does. The example given in the explanatory memorandum was buying a lawnmower for regular domestic use versus telling the supplier that you require the lawnmower to mow a 4-hectare block of land each week. So you're going to need a lawnmower that's going to hold up for longer, and that's where the disclosed purpose guarantee comes into it. So we've got these two guarantees. How do they work in the personal injury context? The first thing you can do is sue the manufacturer. That's section 271 of the Australian Consumer Law. You'll see at 271.1 it relates to a guarantee under section 54 applying to the supply of goods to a consumer and the guarantee not being complied with. Section 54 is the acceptable quality guarantee. Section 55 is the disclosed purpose guarantee. So that means you can't bring a disclosed purpose guarantee claim against a manufacturer, which makes sense because you're not disclosing the purpose for which you require the goods, generally speaking, to the manufacturer. You're disclosing it to the supplier, so the Harvey Norman or the JB Hi-Fi. I'd also point out that, and if you see it, section 271 below 1B, it's an affected person in relation to the goods who can bring the action. So an affected person can be, over to the right, either a consumer who acquires the goods or a person who acquires the goods from the consumer. So you don't have to be the person who's actually bought the goods from the supplier. You can be someone who was standing next to the goods when they blew up but didn't actually buy them, or someone who's in some other way suffered loss and damage as a result of the manufacturer's failure to comply with the guarantee. And I should point out that that guarantee, in case it wasn't obvious, is a strict liability. It doesn't really matter what you knew of the defect as the manufacturer. You're in if they don't, and they're not of acceptable quality. The recoverable damage for this type of action is 272B. And it's any loss or damage suffered by the affected person because of the failure to comply with the guarantee, if it was reasonably foreseeable that the affected person would suffer such loss or damage. So there's that reasonable foreseeability requirement, which is really a test of remoteness. Those types of actions have a 3-year time limit after the date of discoverability, and again, there's no provision to extend that. In the same way as a defective goods action, with this sort of a claim, we're once again within Part VIB of the Competition and Consumer Act because, and I've highlighted it there, a goods guarantee action against a manufacturer falls within Division 2 of Part 5-4. So we're subject to the same sort of most extreme case provisions as I discussed earlier, and you can refer to the earlier slides on that. Now, under the same guarantee, being the goods guarantees, you can sue either the supplier or, in this case, the manufacturer. You can see here that this, and I've said on the right, this action where a consumer is suing the supplier, it relates both to the acceptable quality and, of course, the disclosed purpose guarantee. You should also note that this provision refers to the consumer being the person who takes action. So the person who's actually acquired the goods in trade or commerce from the supplier, not an affected person, as we had under the manufacturer provisions. However, there is one exception to that, which is if you are given the goods as a gift by the consumer. I'm not aware of much authority on what a gift is and how far that term extends, but I mean, a birthday present's obviously going to come within it. So that is one exception to the rule that it's a consumer who's the only one who can sue the supplier in this sort of an action. And they can take action in the same way that an injured consumer would. Now, funnily enough, for this type of case, either a consumer or a gift recipient bringing the action, there are no specific time limit provisions in the ACL. It's an odd one. So the question then becomes, what is the time limit? There is a catch-all provision in the ACL at 236, which is called actions for damages, and that prescribes a 6-year time limit. So the way I understand it is if there's no specific time limit in the Act, which there is for some actions, and that's 3 years, we've discussed, you'd go to section 236 and it'd be 6 years. But the problem is that when you then look to our Limitation of Actions Act, the time limit provisions for personal injury actions, and in particular 27B subsection 4, as you'd see on the left, it says that this part applies despite anything to the contrary in section 2362 of the Australian Consumer Law of Victoria. So that overrules section 236. So while it's a bit unclear, in my view, the case is that we have our normal 3-year time limit, but now with the possibility to extend time under section 23A. With respect to damages, with respect to damages, for some reason, this sort of an action, a goods guarantee action against a supplier, has been omitted from section 87E, which sets out the types of actions to which Part VIB of the Competition and Consumer Act applies. So we're not subject to the most extreme case provisions. It's an interesting omission, and at first some people thought it was a mistake, but now that we've had this amending bill, which has made a raft of changes, and it hasn't sought to bring goods guarantees actions within Part VIB, you've got to regard it as a deliberate choice by the legislature. And so it's an open question as to how one ought to then assess damages and whether we are then come under the Wrongs Act by default or whether we're at large. My own view is that we're then under the Wrongs Act, but I can't say that there's any authority for that. I think you could possibly argue both ways. The provisions of the Wrongs Act are very, very broad. I've got 28C there, and you can see that they apply to any award of personal injury damages, and similarly the non-economic loss provision of the Wrongs Act apply to any award of non-economic loss damages. So arguably they cover the field in this respect. You've then got a provision which says that the manufacturer has to indemnify the supplier in respect of any action brought by a consumer against the supplier as a result of a breach of a guarantee relating to goods. So we've got an interesting situation where if you bring your action against the manufacturer for a goods guarantee, you're going to be subject to the draconian Part VIB scheme, but if you bring it against the supplier, you're not. But then in turn, the manufacturer has to indemnify the supplier. So I'm not sure if this was the way the scheme was meant to work, but on the bare reading of the law, it does work this way. The supplier is probably going to be at more risk on quantum in these sorts of actions, particularly with respect to non-economic loss, because the Part VIB provisions are so draconian, than would the manufacturer be. And I think it's an open question. If you see at section 274(1)(b), the indemnification only extends to what the manufacturer is or would be liable under Section 271 to pay in respect of damages to the consumer for the same loss or damage. So is the manufacturer's indemnity restricted to a Part VIB assessment of that injury, because that's all the manufacturer would be liable in respect of if the consumer had brought the claim against them, or is it the whole whack? As far as the next type of action you can bring is an action against a supplier in relation to guarantees covering the provision of services in trade or commerce. And they're the services guarantees. The first one being that if a person supplies in trade or commerce services to a consumer, there is a guarantee the services will be rendered with due care and skill. The second one is a particular purpose guarantee, which is essentially the same as the disclosed purpose guarantee, in relation to goods actions. Peter will talk about this more, but you'll commonly see this sort of an action with respect to the provision of recreational services to a consumer, like bungee jumping or whitewater rafting or something like that, where something goes wrong. You take action against a supplier in this circumstance under Section 267. And again, I draw your attention to the fact that a 267(1) action is limited to a consumer taking action. It can't be any affected person. It's only the consumer who is the person who acquired those services. There's also a provision which says that the loss or damage which is recoverable is limited to that which is reasonably foreseeable as a result of the failure to comply with the guarantee, either of due care and skill or fitness for particular purpose in relation to the services. The important definitions are, of course, what does it mean to acquire services and what are services? And again, I won't go through those because they're very long, but they are quite broad, and you could stretch them if you had to. And they're inclusive definitions, as with everything in the ACL. For this type of action, and only this type of action, there is a particular section in the ACL, Section 275, which is a bit confusingly worded, but essentially says if there's a contract or an agreement made and the law of a state or territory is the law that should cover that contract or agreement, then the law of that state or territory which would apply to limit or preclude liability for the failure to comply with a guarantee relating to the provision of services, recovery of that liability will apply. So what does that mean? It really means that you have to apply the Wrongs Act. That's what it's saying, because if you enter into agreement in Victoria for whitewater rafting, you'd usually come within the provisions of the Wrongs Act, and the legislature has seen fit to insert a provision at Section 275 directing the application of the Wrongs Act in actions relating to the provision of services and breach of a consumer guarantee. The time limits for this sort of case, well, it's very similar to a goods guarantee action brought against a supplier in that there isn't a specific provision in the ACL that sets out the time limit. So my view is that because of the operation of Section 236, which is overtaken by 27B4, the normal sort of 3-year time limit applies, but now with the possibility of an extension under the Limitation of Actions Act. Damages, it's the same situation as a goods guarantee action against a supplier. For whatever reason, this sort of action isn't included within 87E, which sets out what's included in Part VIB of the Competition and Consumer Act. And also I point out that Section 275, which we discussed earlier, directs attention to the Wrongs Act in relation to the recovery of a liability. So it implies that the damages assessment under the Wrongs Act is the right way to assess damages. Lastly, and this is something Peter's going to talk about in more detail, but there's an interesting question about whether when you're bringing any of these sorts of actions under the ACL, the 4 actions, do you require a Wrongs Act Part VBA certificate? So do you have to get your 5% or more or your 10% or more? Now this is a question which even amongst the panel we have differing views about. It's not a question on which there's any settled law. If you look at what's extracted on the slide here are the non-economic loss provisions of the Wrongs Act, and they are incredibly broad, and they see 28 LC1 applies to a claim for the recovery of damages for non-economic loss, and at 4, this part extends to a claim for damages for non-economic loss even if the claim is founded on a breach of contract or any other cause of action. And 28 LE provides that a person is not entitled to recover damages for non-economic loss in any proceeding in a court in respect of an injury to a person caused by the fault of another person unless the person has suffered significant injury. And I don't think it's possible to get out of it by arguing that fault means negligence and ACL actions aren't about negligence, because fault is defined to include any act or omission. My own views is that for a services guarantee action against a supplier, so the whitewater rafting sort of scenario, you probably do require a Wrongs Act certificate, specifically because we do have that section 275 that directs attention towards the law of the state or territory that precludes limits liability or prescribes the recovery of that liability. So I think you would require a certificate. For a goods guarantee action against the supplier, I think it's not settled. You could possibly argue, we could argue both ways. My own personal view is that you do require a certificate just because of how broad the provision of the Wrongs Act are, and that they catch all awards by Victorian courts for non-economic loss. And of course, with a goods guarantees action against a supplier, as I mentioned earlier, you're not subject to the Part VIB most extreme case assessment. So there's no argument to be made that if you had to get a Wrongs Act certificate, you'd be having to jump through 2 sets of hoops. It's more complicated with the goods guarantee action against the manufacturer or the defective goods action against the manufacturer. Again, I think you can make arguments both ways. Those 2 types of actions are subject to the Part VIB most extreme case assessment regime, so you could say it's a bit unfair to have to go through that and have to go through the Wrongs Act requirements that limit the recovery of non-economic loss. But again, you come back to the point that the Wrongs Act provisions are so broad that it appears that in any Victorian court would have to apply them. So my own view is you probably do require a certificate for these 2 types of actions as well. I think that's been, from what I can tell, the view of some of the major product liability law firms, because I've read some of the submissions they made to the committee that reviewed the Australian consumer law recently for the purposes of that amending bill I spoke about, and they complained that as the state of affairs currently is, you have to go through both the Wrongs Act and the most extreme case stuff in actions against manufacturers. But I do think you could make an argument against that point. It's something that Peter's going to address a bit further. So as to whether a Part VBA certificate is required for ACL actions, it's not a settled area of law. Someone, I suppose, a plaintiff solicitor with someone who's been unsuccessful at the medical panel but otherwise has a pretty good case needs to take it on at some point. That's the end of my paper. The only other thing to point out is that I think everyone should have a little table here, which I've tried to make it as simple as possible. Hopefully something you can pin up on your wall in terms of what the different types of actions, the SLE, the assessment of damages, whether the Wrongs Act certificate provisions and limitation of liability provisions apply. Thank you. I think we'll do questions at the end, right? Thank you.
I have a couple of mates and we have lunch regularly. They're in commercial law barristers, and they always say to me, "You personal injury barristers, you don't do any work, you don't delve into the law." So I'm here to justify that we do delve into the law. We do get down and dirty with it, so to speak. And in fact, we go even further than that. And I reckon not only do we have the most interesting cases at the bar factually, But now when you look at the ACL, we're looking at the Australian Constitution, we're looking at the Judiciary Act, we're looking at conflicts of laws, the interaction between state and federal. So I think we're in the best area of law in Australia, and I think this is another interesting angle or interesting area of that personal injury space. And what I want to do is I want to talk to you about 4 very interesting and complicated areas of the ACL, and they involve, first of all, the recreational activities exception or carve out to the guarantees. Then I want to talk about what Lockie was just briefly discussing about the interaction between state and federal, and for a federal claim, do you need a significant injury certificate or a medical panel finding that supports you? Then I want to look briefly at the manufacturer's obligations and what happens if you can't find the manufacturer, or what happens if the manufacturer is overseas. Can you still sue them, and how does that all work? And then finally, I just want to touch on what's the application of the ACL to medical negligence claims. Now, starting with the recreational services, Lockie talked about the statutory guarantees. So, for example, if you meet the definition of a consumer and you're supplied goods or services, there's various obligations, statutory guarantees. So you're guaranteed, despite any provisions in a contract, that the services must be provided with due care and skill. So essentially it's a common law type negligence wording. And then in respect of goods, that the goods have to be of acceptable quality. And in fact, section 64 of the ACL says that any provision in a contract that says, well, too bad if I sell you this dodgy phone and it breaks in 5 minutes, but you paid me $500, so sad, but you've got no recourse. What the ACL does is says, well, that provision will be void. And there's also some other provisions at section 23 of the ACL about unfair terms of contracts. So there's various ways of saying, well, contractually, yes, there might be an agreement, and there are provisions in the Wrongs Act, I can't remember exactly which, I think it's section 46 or something like that, that says that you can even contract out of liabilities under the Wrongs Act, so you can't do that under the ACL as a general rule. But there's the common exception of the recreational services, which we come across from time to time, and there was a recent and interesting case in Victoria's Court of Appeal last year. So what we have to look at is, there's a few elements to this. But the first element is obviously there needs to be a recreational service, and that's defined in the Act. And there needs to be a contract between two parties, a valid contract. And if you use particular statutory wording, then it may be that those recreational services you're providing, you can actually say under your contract, we're not guaranteeing to provide them to any particular standard. If you get injured from those recreational services, well, that's your own bad luck. So despite the so-called guarantees, it's not guaranteed for recreational services. So the relevant, there's two areas to look at. So there's the ACL Commonwealth, which is federal legislation, and then there's the Fair Trading and ACL state. And the reason there's two different ones is because under the Commonwealth one, it applies to corporations and it relies on the powers under the Australian Constitution. And then the state picks up other people who won't fall within corporations, natural persons and other things. So there's two different acts that you can look at. And both acts in Victoria, unlike some jurisdictions such as Queensland, have this carve out for recreational services. So if you're looking at the ACL Commonwealth, you need to look at section 139A of the Competition and Consumer Act itself, not the schedule. And if you're looking at a claim brought under the Victorian legislation, it's section 22 of that act. And there's one significant difference which I'll come back to, but that's where you'll find those relevant provisions. Now, it obviously enough only applies to services, the supply of services, because it's recreational services. So it could be a case where perhaps you might purchase something, let's say you purchase a bow and arrow, and then the person you purchased it from also supplies an opportunity for you to test it out. And it might be that there's a contract or something, and they say, oh, well, it was a recreational thing, you went off and used it and you got injured and it's your own bad luck. But it might be that you can say, well, actually it doesn't fall within recreational services or services at all, and therefore, because the product was faulty, for example, and you got injured, that carve-out doesn't apply. So keep an eye out for that, and there might also be another way to get around it by misleading or deceptive conduct. Now, the actual definition of what is recreational services, that's to some extent unclear as well. It talks about sporting activities or leisure activities that require a significant degree of physical exertion. And so there's a couple of examples you might be able to think of where you say, well, is it really sport or is it really physical exertion? And I'm thinking maybe a beginner's yoga class. Now, for me, because I'm so bad at yoga, it's very physically exhausting. But whether that does meet the definition, I don't know. What about another example where you might be being provided a ski service, where you're being instructed how to ski, and on your way to go and do that ski run, you get injured? Does that fall within the definition? So there's still some grey areas, but generally speaking, you might think it's fairly obvious in the claims that that come across our desks. Probably the most important and most litigated area of the recreational services carve-out is the use of the language in the contract. And in section 139A sub 3, it says that any provision in the contract has to be limited to death, personal injury, and a certain few diseases. And if it goes beyond that, the New South Wales Court of Appeal has said that the whole provision is void because it hasn't complied with the Act. Now, there's no High Court authority on that, and perhaps it could be argued either way, but that's the current state of the law in New South Wales. And I mentioned at the start that there was a recent Victorian case, and it's a case of Rackich and Bounce Australia, and a similar argument was raised in whereby they were saying that there were various provisions in a contract, and the provisions did follow the statutory wording to some extent. So let's say there were 6 terms of the contract. Let's say the first clause of the contract said, if you are injured with this recreational service and it's personal injury or death, then we aren't liable under the Acts. But then the next clause said, and also we're not liable for any property damage, this, that and the other. And the argument was, does that provision become void because surrounding provisions go far beyond the statutory wording? And our Court of Appeal said, well, we're differentiating that from the New South Wales case law, where the actual clause itself went beyond the Act, and we're saying that as long as the clause is within the contract, even if there are surrounding contracts that go beyond the statutory wording, that's okay. This still bites, and you still get the protection under the carve-out. Now, I mentioned that there is one significant difference in the Victorian Act, under the Victorian Act, if that's what's being relied on, and that is that under the regulations there's actually specific statutory wording, and it says you must actually have this, and if you're having it as a sign, if a sign is going to form part of the contract, then you have to display the exact wording of the regulations, or if it's going to be in the contract again, there's slightly different wording, but it must be that wording. And if it's not, well, I'd suggest, based on the New South Wales Authority, that it would probably be void. So, in short, what one needs to think about when they're dealing with a sporting or recreational activity case where there's been a supplier of a service is there a valid contract? Are both parties privy to the contract? Does it involve a minor? Because it may be that you can't contract with a minor. You have to look at the statutory wording to make sure that the contract is following that. and of course look at the definition of what recreational services means. And I should just add one further thing, that there is also a provision that says if the defendant's conduct is reckless, if there was recklessness, then none of it applies anyway. Now, recklessness perhaps means gross negligence, I don't know. It hasn't really been tested. It's been raised in a few New South Wales cases and it was given short shrift by the judges, so, but that's just another interesting area. Now, I want to delve into what I think has been one of the most complicated things I've had to look into before, and it's really a question of two bites at the cherry for general damages. Now, I don't know what the answer is. Lachie has, he's got his views, and I'm not sure. I haven't come up with a decision on which way I think I fall. Perhaps Lachie's right, but obviously for most public liability and medical negligence claims, you need a significant injury certificate, intentional torts, loss of a fetus. There's a few other exceptions, but generally speaking, that's what you need. And sure enough, the Wrongs Act provides that to claim, if you're claiming damages, no matter if it's under a statute, whatever the cause of action is, the Wrongs Act applies. So Part VBA and the significant injury, you have to get through those thresholds. So it seems clear enough, I think, that if you're bringing a claim under the ACL Victoria, that the Wrongs Act is going to apply. Same jurisdiction, fair enough. But how do we get from the Victorian jurisdiction applying in a Wrongs Act to a federal jurisdiction claim? And that's where I think it gets a bit tricky. Section 138B gives, of the ACL Commonwealth, or the Competition and Consumer Act, gives federal jurisdiction to state courts. So yes, the state courts can make whatever decisions they need to within the parameters of the Act, but they're exercising federal power, they're not exercising state power, and they're just given permission by the Act. So can a Victorian Act encroach on a Commonwealth provision? And this is where I mentioned at the start about the Constitution. And Section 109 of the Constitution, I had to pull my uni textbook out for this, says that if there's colliding laws, state versus federal, the federal law prevails. Now, it's not entirely clear that they are colliding, and there's a couple of High Court decisions that have looked at previous provisions in the TPA and have really said it's really got to be colliding full on. And perhaps there's an argument that there is no direct collision because there's a general damages entitlement and then there's a certificate of a threshold. It's arguable, perhaps there is no difference, and there are some provisions in the Competition and Consumer Act that say the idea of the ACL is not, generally speaking, to disturb the state law, and unless there's something significantly inconsistent, really the state law is there to fill in the gaps of the ACL. So it's not entirely clear-cut, and there's no case law that's looked at any of this. And then it gets a little bit even trickier when you go to the section that Lachlan pointed out about 275 of the ACL, which says if the law of the contract is the state law, then the state's legislation applies, despite the ACL Commonwealth claim. So if it's for services, there seems to be a pretty good argument that if there's a contract there where the law of the contract is Victorian law applies. Okay, so yes, I think that there's a good argument there. But unfortunately, and more confusingly, there's a couple of inconsistent decisions on the point. And there's one decision of Insight Vacations and Young, a 2010 decision, and that said that the caps on damages under the Civil Liability Act, the equivalent of the Wrongs Act, did apply because the contract was formed in New South Wales and the Wrongs Act caps were a way of limiting liability, so they did fall within the purview of Section 275. So despite there being a Commonwealth Act, they said, that's okay, too bad, you're stuck with the Civil Liability Act damages. And there were 2 judges who made that decision. That case did go on appeal to the High Court, but it wasn't appealed on that point, and it wasn't looked at further. And so you might say, well, that's pretty persuasive authority, and Victorian courts normally bow to the state appellate courts under the stare decisis and precedent laws. But unfortunately, there's a further case and a later case of Glenworth Valley horse riding, which I was discussing with someone earlier this morning. And McFarlane in that case, without reference to the earlier case, said that damages don't fall within the liability meaning of section 275, and therefore you're stuck with damages under the ACL. So you've got 2 polar opposite decisions. One's not considered the other. And I mean, it's potentially his decision might be undermined because he has applied the wrong sections to damages, but that's a by the by. So really the law is, as you can see, quite, not only is it very complicated, but it's also very inconsistent. And then you think, well, of course 275, as I said, only applies to services. What about to goods and the manufacturer's liabilities, and how does all that work, and where's the law on that? And there is no law that I know of. So unfortunately, I'm here to say I'm more confused than I was when I started this presentation, preparing for this presentation, but that's the state of the law. Then just briefly on manufacturers. And as you know, that generally speaking, if there is someone who's manufactured a product, let's say it's manufactured in Queensland or Kansas or wherever it might be, and you buy that product and you'll get injured in Victoria. Generally speaking, the law says that despite you being injured in Victoria, the cause of action arises, and therefore the substantive law is the law where the product was manufactured. Now, if the product was manufactured in Japan, what a nightmare, because you'll be looking at the Japanese substantive law and trying to work out what's available, what damages, what cause of actions, etc. So the really important thing about the ACL for those types of claims is it seeks to extend to extraterritorial jurisdictions. So provided you fit within Section 5 of the Competition and Consumer Act, you can bring a claim against a manufacturer in Victoria, even if they're overseas. But you have to get it within the web of the wording of Section 5. Now, Section 5 is rather broad, thankfully, and it says, obviously, if there's an entity that's incorporated in Australia but their place of business might be overseas, they're still covered. There's an arrangement with New Zealand, so any New Zealand companies are covered. But you can think of examples where it may not be so clear because, let's say, going back to the Japanese example, maybe from time to time they sell products here but they've got no presence here, there's no office, etc. That's when you need to look at whether they are carrying on business, and that's the most broad part of Section 5. Are they carrying on business in Australia? And there's case law that says provided they are supplying goods or giving Australia products or whatever, supplying to individuals or companies on a regular basis or a continuing basis, that's enough to fall within the extraterritorial provisions. So pretty important stuff. And it used to be that to sue someone on an extraterritorial basis you had to seek ministerial permission, but a bit like what Lachlan was talking about with some of the changes that are about to come through, that also is about to come through. So you'll no longer need to get ministerial permission. And of course, the other thing is that there are provisions in the ACL that say, under Section 67 of Schedule 2, that say if there is a contract that says, regardless of what happens, the forum of our contract is Japan, let's say, the ACL says, no, unfortunately you just can't even do that. There's some exceptions, but generally speaking, you can't avoid by a provision in a contract the jurisdiction of the ACL. So it's pretty powerful stuff. And finally then, I just wanted to talk briefly about medical negligence claims. And it's something that perhaps isn't pleaded as much as could be. But also, there's, I think, quite a significant distinction between public patients and private patients. Now, with public patients, it seems hard to say that they fit the definition of a consumer. Their services of less than 40,000, or you might be able to make an argument. And then some of the provisions in the ACL also require a trade and commerce aspect to it. Somewhat hard to say that trade and commerce fits with a public hospital. The actual definition itself does talk about not-for-profit organisations, but I still don't know if the ACL would apply to public hospitals. Private hospitals, though, I think that's much clearer. So private treatment and private hospitals, private services, one would think you're a consumer paying for the services, or if you're getting a hip replacement and you will ultimately purchase the hip, then one would have thought you'd also meet the definition. And there is a case going back to 1991 where Justice Wilcox looked at whether nurses supplying services in a private hospital fell within the TPA, and in his view, they did. So it seems that there is good reason to be pleading the ACL in medical negligence claims. And I think that's everything I have to say. Thank you.
Peter, can I just clarify something, please? You've got a paper we're sending out today?
I do, yes.
Will be emailing out to everyone in the course of today?
Yes, it will be. Yes, thanks very much.
So, any questions after having had all that information thrown at you?
In the case where you've got a supplier who failed to identify the actual manufacturer under that section 147 and becomes a deemed manufacturer as well, even though you've supplied the product, would that preclude the supplier from relying on section 274 indemnity against the actual manufacturer? If that makes sense.
Good question. I think if you did subsequently identify the manufacturer, you'd be fine. And equally, as acting for the plaintiff, I'd not only plead that you were the deemed manufacturer by reason of your failure to respond to the section 147 notice, but I'd plead the supplier stuff as well. Right. So to be in the alternative. But yeah, it's a very good question. They're quite draconian notices, and there's certainly no obvious way to then avoid being the deemed manufacturer once you've
even if you've identified
defaulted. Yeah.
Thank you.
Any other questions? Well, thank you all for coming along this morning, and thanks to both Lachlan and Peter for presenting very interesting material, which is no doubt getting you all off food for thought. Go out and make some law.
I think both Peter and I, if you've got questions later, email or phone is fine, so we'd be happy to answer them. Thank you.